place has been determined, how it's going to be set up, and where the jurors will come from, where the parties will be. It's still being discussed. I've asked counsel for the state and counsel for the defense to first discuss what they would like. And if it's acceptable to me, then I'm more than happy to follow their agreement if I find it acceptable. If not, I'll come up with a placement plan. I don't anticipate a problem there. We've agreed that we will meet at 8 in the morning, and that the tow truck will be there with the vehicle so that we can all have an agreement as to its sighting and positioning before the truck driver puts it down and in place, to avoid duplicate efforts if there's something that needs to be tweaked or adjusted in the place where it's determined that he wants to set it down. So everyone is to be there at 8 in the morning, and we'll get it properly placed. Mr. Sharon's going to work with the media as to where the media can have their camera. The media has been advised that there are to be no pictures taken of jurors, so I anticipate that they'll want to take their pictures. First, the sheriff is going to be involved in where, it's already agreed where the media can be, and the sheriff is going to be involved with Mr. Sharon as to when and what and how the media will have access to be able to get the pictures that you all want. And then the jurors will come, and one of the issues we need to agree on is how long the view will last. And then after that, they'll be brought back into the courthouse and the trial will resume. So right now, the things that are definite, or we'll meet at 8 o'clock for the placement of the vehicle. Detective Grimstead is here, and the car seat can be delivered to him. State and defense want to be present when the car seat is placed in the vehicle, so you all need to agree on a time, and then I'll come. Why can't y'all need to discuss it? But it seems to me it can be after hours. Yes, sir.
A couple suggestions for the court. I've mentioned to the court that I was going to bring up two things while we were doing this meeting, and I also told the court we would do that on the record. The first thing is I have an order prepared. It's a release order. It just needs to be filled in. You've seen this before. This is a topic of discussion before that would allow Detective Grimstead to get this car seat. We do expect to recall him to the stand to lay some foundation for some things. What I propose to the court, we have absolutely no objection to the defense being able to access the vehicle. They've always had that right. We don't have any problem with them doing that with Detective Grimstead, but for efficiency's sake, we've made arrangements with the person that's housing the vehicle right now to allow Detective Grimstead to access it and place the seat and get the appropriate measurements. That would allow the defense at any break or during the lunch break, this record yard is only about 5 minutes away, to send a designee to go confirm with Detective Grimstead what he's done. He's got his tape measure and all that stuff with him. Alternatively, if there's a 3-person defense team here, if one of them wants to go with Detective Grimstead now, for efficiency's sake, it would allow us not to have any delay in being able to present his testimony this afternoon, and that's part of the reason we asked him to come down last night.
Have you all discussed this with each other?
We didn't have an opportunity to do that because we didn't want to do that off the record.
That's what I'm wanting y'all to do first, is talk to one another.
Then let me do that now because
Please do so.
Judge, is this something that has to be decided at this moment, or can we have an opportunity to think about this and talk about it? Because I can tell you, we certainly don't like the option of one of us leaving and not being present during the trial. That's just not gonna work for us.
Well, we're gonna take a morning break. Well, we can do it at lunch.
Okay.
Okay, so do it at lunch, because we have a timeline
All right.
that we have to meet. So do it at lunch. That solves that. What's the other concern?
That's all for right now.
Okay. All right, have you showed them the order that you're proposing I sign?
Same like before, just needs to be filled.
Yeah, as to form.
You have no objection as to form?
As to form.
Okay. Bring it up and I'll sign it.
We had previously objected to the entire procedure.
I know. And you're not waiving that at all.
Specifically, having this reinstalled for purposes of review, we objected to that, continue to object.
All right. Now, when is it you anticipate putting Detective Grimstead back on the witness stand?
Right after lunch.
Okay. This is what makes sense to me. I think he ought to take the car seat. He ought to go down there with his measurements. He ought to put it in the car. You all can go at lunch with your measurements and see where you agree or disagree. Then this afternoon, wherever the disagreements may be, we can discuss that, and I can say, I mean, it may be that you're fine with it, it may be that you're not fine with it. You can tell me after lunch, and then I could say what needs to be done about solving the problem. Does that cause a problem for the state?
That's my recommendation to the court. I think that's the most efficient way of doing things.
What says the defense?
We'll get with Mr. Evans at lunch and discuss what, if anything, that we'll do at that point.
Okay, well, I'm gonna go ahead and direct the Detective Grimstead, can take the car seat and install it.
Thank you, Your Honor. Judge, the only other thing before Grimstead leaves, we had a discussion yesterday, and I told the court this morning, we would put this on the record as well, about whether we would actually be tendering the vehicle, because there's some question about whether it's an item view versus a scene view, and could qualify, quite frankly, as either one of those. So, what we intend on doing is tendering the motor vehicle. The way we're going to do that is I'm going to direct Detective Grimstead to leave this on the dashboard as a piece of paper. It says defendant's Hyundai Tucson, and it's got a state's exhibit sticker 650, so that we can actually tender the vehicle into evidence. Technically, the vehicle's not going to go to the clerk's office. Instead, we're going to ask that this piece of paper be substituted for the purpose of the record, and then Cobb will take custody of the vehicle after the trial of the case and retain it for posterity.
Okay. Well, whether to put in evidence or not is certainly your decision. Are you making a tender at this time?
No,
There's not a jury?
I'll do that with Detective Grimstead.
This afternoon?
Yes, ma'am.
All right, well, you all have been informed, and you'll know how you want to respond when the time comes. That's gonna impact my charge, but that's fine, I can fix that. Okay. So, we're gonna meet in the morning. We'll all as a group decide, if we agree with the placement of the vehicle or not. If there are disagreements, I'll make a decision, we'll put that on the record. Mr. Sharon is going to manage the media according to the sheriff's direction. And topic for the morning is the placement of the parties during the view. Again, I want you all to confer and a morning report where you would like to stand. If there's agreement, good. If there's disagreement, I'll make decisions. We'll come back in the courtroom and make a record. I have a charge. It's going to have to be adjusted given the state's decision to place the vehicle into evidence. I'm going to work on that. I will give you all a copy of what I've come up with as soon as I can, certainly before tomorrow. All right, any other concerns about the view from this state
No.
and from the defense?
Not at this time.
All right, are we ready to go forward?
Yes, sir.
Bring the jury.
Let's all rise for the jury, please.
Wow,
Okay, I know you had that.
it's amazing how fast you sometimes make the adjustments.
Okay.
I'm sure you did.
She's available.
I appreciate you doing that.
Yes, ma'am. Be seated, please.
Ladies and gentlemen, good morning. We're ready to resume the trial. Please proceed.
Morning, Detective.
Morning, Counsel.
As part of the investigation, y'all spoke with and took some evidence from Ross's wife, Leanna Harris.
What are you referring to, sir?
As part of your investigation, you spoke with and took some evidence from Leanna Harris, Ross's wife.
I'm asking, are you talking about the search warrant at the residence? Are you talking about when she was at headquarters?
Well, let's do this.
Okay.
Part of your investigation, did you ever have any conversations with Leanna Harris, you or your detectives?
Yes.
As part of your investigation, did you or your detectives seize any evidence belonging to Leanna Harris?
Yes.
All right. Is she still a suspect?
No.
All right. When did you rule her out as a suspect?
Objection relevance.
No loud ever objection.
There's no date that we decided. No evidence has come forward to bring us up to the level of probable cause which you need to get a warrant to arrest Leanna Harris. We've never reached that point, so.
Okay. So you don't have a date certain or a time certain when she was ruled out as a suspect?
No.
Okay. Was that recently?
No.
Was it recently?
Like how recent? Like within the last 2 months?
Mm-hmm.
Or the last week?
Mhm.
What are you asking, sir?
I'm asking when you ruled her out as a suspect.
Objection asked and answered. He said he didn't know, Judge.
Explore it.
Leanna Harris has been a suspect in this case all the way through it. The case is at the final conclusion point and no evidence. So, there's 2 ways to look at her as a suspect. Is she being actively investigated? No, she is not. Did any evidence rise to the point where we had probable cause to take an arrest warrant for Leanna Harris? No, we did not. So at this time, is she a suspect? No, I cannot say that. She's still listed as one on the report, but she is not part of an active investigation.
All right. Was it your theory then that she was aiding her husband in his quest to live some wild, child-free, divorced life? Is that your theory? Why she
At
was
the
a
beginning,
suspect?
at the beginning of the investigation, Leanna made similar comments that her husband did. comments about how her fear was of her son dying in a hot car.
I hate to object to this line of questioning, but now we're going into hearsay at this point.
Sustained.
Thank you.
So, due to,
That's been sustained. I didn't ask you what she said.
oh, I'm
So
sorry.
when the judge says sustained, that means you can't keep talking, okay?
Okay, I'm sorry.
You seized her computer, her MacBook.
We did.
And you didn't find any evidence on that MacBook inculpating her in any way, did you?
As I've answered before, we did not find any evidence to rise to the part of probable cause to arrest Leanna Harris.
Okay. Well, the way you're talking, it sounds like you think she's still a suspect. Is she?
Objection, argumentative.
He has him on cross. You can answer.
Thank you, Judge. That's been answered.
Okay. In fact, what you found on one of her devices was about 30,000 images of family pictures, mostly of Cooper Harris.
We did.
You didn't let her have that back for her son's funeral, did you?
At the time, it was still an active investigation, a very active investigation. The photographs were on a piece of evidence. It was discussed thoroughly, and at the end, the decision was made not to release the photographs due to it being a piece of evidence.
So that's no. You didn't give her back her photographs to have when she buried her son. Is that right?
That's correct.
All right, so we've heard some evidence that Leanna Harris went to the treehouse looking for her husband. And we know that she spoke with Wesley Houston there, and you spoke with him.
I did.
Okay. And she was also, she spoke to some of your investigators there, Detectives Rose and Stockinger at the treehouse?
That is correct.
Okay. That was recorded, correct?
I believe so.
Well, you've had a chance to listen to that interview of Leanna Harris done by Stockinger and Racy, haven't you?
I'd have to refresh my memory of the notes. I have not listened to it recently.
Okay. Well, if an interview was done by your detectives at the scene immediately after she discovered the death of her son, and it became part of the case file, are you saying you're not sure if you listened to that interview?
No. What I'm saying is right now, I can't tell you that there's recording. I'm sure I've listened. If there's a recording, I've listened to it. If it went into my case file, I've listened to it. But sitting here right now, I can't tell you right now.
What you learned about the initial stages of investigation as far as Leanna Harris was concerned, she didn't show much emotion, did she?
Yes.
Yes, meaning she did not show much emotion?
Yes.
It's been reported there were no tears.
Correct.
And you testified about this in July of 2014, that she didn't show any emotion and she didn't ask to see her son, right?
Correct.
And then later on, you had an opportunity to speak with Leanna Harris at police headquarters,
That's correct.
and you searched her belongings.
I did.
You went through her bag, you went through her wallet.
That's correct.
She wasn't in custody.
She was detained.
She was detained.
And she was not allowed to leave. She was being questioned and the results or concerning her, the son's.
Do you have any report there in your little binder that says Leanna Harris was detained?
She was brought to headquarters, and she said, if you listen to the interview, We speak about, you hear of your own free will. She says yes, but if pushed, I would have to say, yeah, she wasn't free to leave.
Okay. In other words, you don't have any report that says anything about the fact that she was detained?
No.
And you've never testified before about the fact that she was detained at headquarters?
No.
In fact, isn't it true that what happened was the detectives were concerned about Leanna's ability to drive herself
That was
because
part
of the news that they had just had to deliver her to her about the death of her son?
That was part of it.
And then once she got there, apparently, we're now hearing you made the decision that she was going to be detained.
When she got there, if she would have decided she tried to leave at that time, I would have had to say no.
So after you went through her stuff, you had an opportunity to observe her demeanor,
That's correct.
and your report, you indicated that her demeanor was calm and collected,
I do.
and there's no report that you made that she was crying or had tears or showed any emotion, right?
That's correct.
Is that why she was a suspect?
And the statements that she made.
I'm asking about her demeanor and emotion.
Yes.
She wasn't reacting the way you thought that she should be reacting. Isn't that true?
That's part of it.
And we've all seen the recording where you allowed them to speak to one another,
That's correct.
right?
That is correct.
And if he was detained and she was detained, then obviously you thought something suspicious was going on, so you wanted to put them together and observe them secretly.
That is not. They're in a room with visible video cameras. They had both just been interviewed in regards to an investigation. They knew they were being recorded, or should have known they were being recorded. And they both asked to see each other.
They should have known.
They should have or did know.
It's not like they had a lot of going on then, stress-wise, was it?
I don't understand your question.
We see in that video that Leanna Harris is she's calm and she's reassuring to her husband. Isn't that true?
That's true.
And we don't see her falling out, having a fit, crying. We don't see any of that, do we?
No, we don't.
And that's why you consider her a suspect, because you don't think she reacted the way you think she should have.
And that is a very small part. It's a whole picture. You have to know all the pieces to know why she was considered a suspect.
We do have her see on that recording almost the entirety of the time they're in there. We see Ross crying and carrying on and being very emotional.
Yes, at that time when Leanna and him were together, they were both very, well, he was very emotional.
He was way on one side of the emotional spectrum, and she was on the other. Is that fair to say?
That would be fair to say.
And we also see him continuously wiping his eyes and wiping his nose.
True.
Okay. That's what happens when you cry, right?
Agreed.
Okay. And in fact, at one point in time, he's asking her for a tissue, and she says, "All I have is a sanitary napkin."
Correct.
Okay. That's something when you cry, you need tissues, right?
That's
Or
correct.
you wipe it on your shirt.
That's correct.
dead wrong about Leanna Harris.
I won't
She's
say
in
that.
no way involved in any sort of conspiracy with her husband. Is she?
And that's been answered. She is not a suspect involved in an active investigation at this time.
Isn't it true, you're looking for a conspiracy, and you're looking for nefarious motive, so you're seeing what you want to see.
Judge, now I'm gonna object if that is argumentative.
It is argumentative.
Okay. Thank you, Detective.
Thank you, sir.
Detective, just touching back on that, I guess the last thing we heard, I'm kind of a train of thought guy, so.
Yes, sir.
As we were talking about the interview, or not the interview, the discussion between Leanna and the defendant in the interview room.
Correct.
You saw him wiping his nose, asking for tissue, things like that, saw real tears. See any of that before he was informed?
He's
he was-
leading, objection.
That's not suggestive, Judge.
I didn't hear a whole question, so it's hard to
Okay.
say. So
Was-
if you will state your question.
I will, thank you. Was that before or after he was told he was going to be arrested?
That was after.
Was that before or after he was put back in the cell and with, as he complained about, an uncomfortable cot and a metal toilet?
After.
And the majority of the time he's in that room, is he complaining about himself?
No. Well, yes, I'm sorry. He is.
Okay. And when you talk about him being emotional and things like that, do you notice times in there where he actually is more interested, or is interested, sorry, that's argumentative, interested in what other people are saying about it?
That's correct.
And actually sees a phone buzz and starts asking, calms down, oh, who's texting?
That's correct.
You talked a little bit about whether you seized any computers. When you initially seized these computers, did you know who each computer belonged to? If
No.
it was used by defendant, by
They're
Leanna
electronics.
Harris?
No, they're electronics found at the residence.
Okay. Now, did you in fact in some of the computers find evidence that, going back years, that they had had problems and there had been issues of infidelity that she somewhat knew about?
Yes.
The defense asked you about whether you turned over pictures for the funeral and things like that. Was that a big discussion both with the DA's office about whether we could do that, given the investigation, and whether
I'm
the
gonna object. I guess that would be hearsay about some discussion that was had in the DA's office.
judge had already asked about discussions at the office and who he consulted about whether to turn over these pictures or not?
You can go into it.
Thank you. Were there discussions about the legalities of it and whether it would taint evidence if you're still investigating and examining a computer and then trying to turn it back over?
That is correct.
Okay. And did you eventually, did y'all actually try to extract all the photos you could get off of her computer and turn them over to her attorney?
We did.
And I think you answered this, Detective. Mr. Kilgore tried to portray it as you thought she was a suspect because of her demeanor. Were there other reasons and things like that? Was demeanor just a part of it?
It was multiple reasons.
Okay, and the same thing with the defendant on scene. Was that just one of the things that initially y'all took into consideration as far as when to investigate and how to investigate further his behavior?
It was just a piece. It was a piece of the investigation.
Just to start off with, just a few things to clear up. Mr. Kilgore asked you about messaging with Elizabeth Smith, the defendant messaging with Elizabeth Smith on the morning of. You remember that?
Yes, sir.
Oh, great. Now, this was a woman he had actually met up with twice, correct?
Correct.
But they had talked for months and months, numerous times, about sexual conversations.
Correct.
So did they meet up every time they had a sexual conversation?
No.
Okay, and just to be clear, what was the statement? I think Mr. Kilgore portrayed it as he asked her to meet him to have sexual acts, correct?
Correct.
Okay. What is the actual statement that he says to her that morning? Well, we've heard enough of
You can
okay, you can say that. Yeah.
you can come suck me today.
Did they ever discuss meeting up, where they're gonna meet up, anything like that?
No.
Okay, and did you see the time on that, by chance?
I think it was 7,
Let me just show you, just so we're accurate.
yes. 7:25:56 a.m.
Okay, so that's 2 hours before he locked Cooper in the car, correct?
That's correct.
Were there numerous occasions the defendant would message people and talk sexually without actually meeting up with them?
Correct.
Okay, let's clear up some of these issues about the phone calls on the scene. Defense counsel asked you some questions about, could your officers have hit butt dialed or redialed or something?
Yes.
How many calls were reflected on all of the records to Little Apron or to Home Depot, just generally, at 4:25 on June 18th?
2 calls.
Okay. When you spoke with the defendant, how many times did he say he called Little Apron Academy?
2 times.
And the Little Apron Academy records, where it shows the extension dial to go into it, was that dialed on those occasions on June 18th?
It was dialed both times.
So this was not just some general call to a general number.
It was not.
So defense asked you if it could be consistent with butt dialing and things like that. Could it also be consistent with he made a call, it got connected, and then he got detained while the phone was still going?
That's correct.
All right. One other point of clarification, I think you may have covered it, but the GoPro videos, the difference, one of the differences between the times that you ran initially back 2 years before the GoPro videos, in addition to different traffic patterns, school, things like that, did you actually also start the video much earlier in the GoPro videos as far as being in the parking lot and driving through the parking lot, as opposed to just leaving Chick-fil-A back in 2014 with those times?
That's correct.
There was a question about the radio, I think. Let's see. Okay, in your interview with the defendant, you asked him about whether he was listening to the radio or anything like that, and what he was doing in the car, correct?
Correct.
Okay, I'm gonna ask you, if you look at the transcript, would that refresh your recollection about what exactly he said
Yes.
regarding what he was doing? When you asked him, when you left there, were you on the phone? What did he say?
Nope.
Were you talking to anybody? What did he say?
Nope.
What were you listening to on the radio?
Probably 104.7. I mean, I just know I wasn't doing anything. I just left.
Now, did he even say he definitively was listening to the radio?
No.
Did he say he was doing anything at that moment whatsoever distracting him?
No.
Okay, going back to the passcode again, when he gave you that passcode, from that video, didn't you actually tell him, we're charging your phone and we know you have a passcode?
Yes.
And with the Whisper app, did it actually, even though it was hidden, did it also have a different passcode?
Judge, I'm gonna object. He's leading every question.
Did it have a passcode? How was that leading? I would say,
Well-
it did have a passcode, didn't it? That would be legal.
He's testifying and then simply having a witness agree or disagree with what Mr. Bourne is saying, and that's what leading is, and so I haven't been objecting every time, Judge, but I'm gonna start objecting.
Carefully phrase your question so as not to be leading, but I didn't find that last question to be leading.
Thank you. The Whisper app, after it was, you found that it was hidden on the phone, did it have a separate passcode as well?
Yes.
Okay, you pulled the defendant's Tuscaloosa PD records. I know he said that he'd been there 5 years, I guess. How long had he worked as a dispatcher per the records that you received?
3 years.
Defense counsel asked you some questions about when you, at the scene after he got handcuffed and in the interview, were these, I think, it was said, is a good opportunity to act up. Would it also have been a good way to convince you people, or you detectives, officers, of his story?
Yes.
Objection, speculation.
It's the converse of the exact question the defense asked.
Well, he didn't object to my question.
Regardless, you can ask.
Thank you. Would it also been a good opportunity to convince you guys of his story or talk his way out of it?
Yes.
Okay. And when the handcuffs came out, did he immediately, his demeanor change, and try to talk his way out of it?
Yes.
Okay, we talked a lot about smell and things like that. We talked about, excuse me, crime scene tech Shumpert, Martin Jackson, James Hawkins, first responders, things like that. Other than Captain Farrell at the scene, did anybody put their head in the car?
Not that I'm aware of.
Did any of those guys ever get in the car, as far as you're
Not
aware?
that I'm aware of.
The people who actually got in the car that evening would have been you, Captain Farrell, and Grimstead, correct?
Correct.
And even though none of these other people got in the car, the child's out in the elements. Make sure we're clear. Did you ever actually get down and say that you smelled anything coming from the child? Did you get close to the child at all?
No.
Okay. But these other people, James Hawkins, Bradley Shumpert, Martin Jackson, they also were down with the child at some point and noted that they smelled something.
Correct.
Now, when the defendant, given his timeline, he got in the car that afternoon after the car had been out there all day. According to him, was there any emergency situation for him to worry about when he first got in that car until he got to Acres Mill and had discovered his son?
No.
Any of those witnesses that were at the scene, first responders, any of those, did any of those people open up the defendant's car door at lunch after the child had been strapped in the car for 3 hours?
No.
Did any of them open up the car door at 4:15 that day after the child had been strapped into that car for 7 hours almost?
No.
Did any of them experience opening that hot car, sit down and drive off within 3 seconds without the windows rolled down?
No.
Did any of those others drive for minutes with this deceased child sitting inches from him?
No.
There were several questions about Detective Murphy and things like that. All the interviews he did, were those all recorded and turned over to both parties in this case?
Correct.
Okay. And a number of those people who he interviewed, were you actually present for the interviews as well?
Yes.
And these people that he interviewed, did they actually come in here and give live testimony, a lot of them?
Yes.
Going back to lunch, you were asked about Winston Milling and whether he initially, I think he was interviewed a day after the incident, correct?
Correct.
And that he forgot to mention that he went to Home Depot.
Correct.
In fact, he said that when they were dropped off, what did he say about it when they dropped Ross off? Did he even remember where he dropped him off or if it was somewhere different?
He did not remember.
Now, the defendant, was he able to give vivid details of that day, from waking up to strapping the child in to what he said to him throughout the day?
That's correct.
And we saw how he reacted when he was talking about the Publix and things like that.
Objection. That's just a statement, there's no question.
That was a segue into the next question, Judge. It was a transition. Thank you. During that time, did you guys have any information that he had gone back to the car when you're talking to the defendant as opposed to Mr. Milling?
No.
But luckily, who was it that had gone back and reviewed videotapes and saw this happen, looking at badge access, were wise enough to go back and look at this?
I did.
Did Home Depot actually pull that video too?
They did.
Now, we saw that the receipt that was crumpled up and thrown away, the Publix receipt, which has been introduced. In that video, Did the defendant actually open up and look at the receipt and see which exact receipt it was at that time?
No,
He just looks down, sees the receipt, and tosses it.
correct.
You were asking questions about the vacation, Googles, and things of that nature. Just wanted to clear up some timing on that. Let me go back and ask him. That's a little haystack. I believe it's 6:07, Brian. Thank you. Looking at the timing of these texts, she's the one who first texted him, correct, on June 17th at 10:19 a.m.?
Correct.
Okay, and he texts her back at 3:16 p.m. on that same day, correct?
Correct.
And so the email, though, that he sent to the travel agent wasn't until 2 minutes after that, correct? So when he told her he was just waiting to hear back from the agent, that wasn't true, was it? While we're talking about vacations, did you also uncover any other Google searches about vacations or going to far-off places on his computer?
We did.
Okay, on the Lenovo, did you, on June 13th, find anything, Google searches about remote islands to move to?
Yes,
Do you remember the names of those islands by chance?
we do know.
Okay. Also, June 17th, the day before Cooper's death, were there also searches for other islands like Antigua and Sandals, places where children can't go?
Correct.
And the defense asked you several questions about, well, did you make a report about this email from Ms. Coyle? Was that any evidence that you actually sought out and obtained?
Yes,
Okay, that both parties have.
yes,
Did you have any evidence that he ever responded to that email or called her, anything of that nature to follow up with?
no,
He also asked about any information child-free, if you follow up, put that in your report. Is that all information that was provided to the state and then to the defense?
it was.
Now, after that July 3rd probable cause hearing, which was about 2.5 weeks after the arrest, was there a ton of evidence that you basically recovered and turned over that was a specific supplemental was not done?
Correct.
And did that only pertain to things that the defense is saying or that they want to introduce?
Judge, that's leading.
It's a yes or no answer. It's not. I'll rephrase it, Judge.
I'd like to find leading question.
Okay, thank you. Well, there are lots of stuff that that you uncovered from, say, Whisper app about all of these conversations, his double life, all these other things that came out. Did you do supplementals?
He's just testifying.
I'm pointing his.
It's difficult to make a ruling until I hear an entire question. He was in the midst of one. Finish.
Thank you. All of these things you found from the Whisper posts and things like that. Did you do supplementals on those things as well?
Not all.
Okay. Did you do any supplementals about his statement saying he leads a double life?
No.
Okay, going back to the parking lot videos, I think defense counsel asked if he could have backed into the wood line and things like that. Now those trees back there, this tree's much bigger than the ones right beside where the defendant parked.
True.
And is it fully wooded back there?
True.
Okay. In the vet video, does he actually say, that veterinarian, and do you see video of trees waving in the background?
Correct.
And he says, windows down and still be hot enough to kill.
True.
You were asked several questions about people walking by the car. Now, some of these people, I'm sure the jury saw this, they were on the other side of the roadway from the defendant's car, correct?
Correct.
They weren't walking right by it?
Correct.
Okay, the defendant's back and rear passenger and driver's side door or windows, are those all tinted to a degree much more than the front windshield and the driver's side window?
That's correct.
And these people that were walking by the car, did that car belong to them?
No,
Did Cooper Harris belong to them?
no,
Did they go back at lunch and open up the door when they walked by?
no,
Did they spend over 30 seconds in that car with that child that morning before
No.
closing the door on them?
no.
Let's talk about that June 3rd, 2014 video. The defense played in here with the defendant when he parks messing around inside of that car. You remember that video?
Yes,
Getting his stuff out.
correct.
When you see that video, is he turning and leaning right over where that child would have been if the child was in the car that day?
Correct.
Defense asked you some questions about the child, about Cooper falling asleep on some videos and things like that.
Correct.
Okay, were these times all before 8:45 or after?
After.
Are you
Oh,
sure?
no, I'm sorry. The times where the child was sleeping is usually before 8:45.
Were those before he came in and had breakfast at Little Lake?
Yes,
Was there any evidence, like on the day of June 18th, that the child had slept in later?
yes,
Now, you spoke with the employees at Chick-fil-A, and they told you how he would act when he came in from Chick-fil-A.
I would object to hearsay.
The state.
Did you speak with those people? I'm not asking you what they said. Did you speak with them about that issue?
yes.
Okay. Talking about things on the computer as well, and the effects of objects in a car, I'm going to show you what I'm marking for identification purposes as States Exhibit 651. Detective, showing you States Exhibit 651. Do you recognize that?
I do.
How do you recognize that?
This imager or a photo that came from his computer?
And did you uncover this imager? Did it have a title that was on his computer from June the 6th of 2014?
Yes.
Okay. And what was the title of the actual post?
So just to summarize, it says, I guess it did get hot in the car today, or it did get hot today.
Your Honor, I tender States Exhibit 651.
Just the same objections that we previously made regarding using electronic evidence.
Admitted over objection.
Basically, melted gummies.
Yes, sir.
You were asked several questions about testimony given at the probable cause hearing July 3rd, 2014. And again, that was just a little over 2 weeks after arrest.
Yes.
At that point, was he under the arrest for intentionally killing his child? Was he under arrest for that? Had he taken out any warrants for
No.
malice, murder, or anything?
We had not.
Were you still investigating it?
We were.
He was basically, that was subject to a warrant for negligent homicide, correct?
Correct.
All right. Usually, as you told the defendant, how long is a probable cause hearing before there's a hearing?
30 days.
Did you ask to move this up?
I did not.
Was this something that by July 3rd that you guys had already gotten everything together, had your whole case file, had finished your investigation? Or is this something that y'all were just in, I guess the investigation was in its infancy?
It was still in its infancy.
Okay. Now I'm going to go back regarding that. The defense asked you some questions from a transcript involving the PC hearing regarding the how hot does it get in a parked car video. I'm going to go back over that a little bit just to make sure we have the full context of everything. And at that probable cause hearing on page 59, you had actually discussed the defendant telling you he had looked at some video on the internet. Okay? And to be fair, looking at page 60, and perhaps inartfully, was it me who actually used the term, did you find a web search on his computer, the Lenovo, related to what you described?
That's correct.
Okay. And did I ask you if you actually found the video on his computer?
Yes,
And then you went on to describe what the video was?
that's correct.
Okay. Now, looking at it further,
I'm gonna object. He's got the transcript in front of him, and he's misquoting what was actually said on page 60.
did you find the web search?
Object to the form of the question as it was asked.
I'll get him to read it again. When I asked you that question, what did I ask you?
Did you find a web search on his work computer, the Lenovo, related to what he had described to you?
Okay. And what did you say?
I did.
And then what did you say?
Did you actually find the video on there that he described to you?
And then what did you say?
I did.
Okay. So that was actually me using the term web search. Okay. Now, did you testify later about this as well?
I did.
So in this same hearing, you gave further testimony about this issue. Let me ask you this. Did you ever say that the defendant got on there and there was evidence that he Googled hot car searches, death, anything like that?
No.
Okay. If anybody said that, that would be untrue, correct? Also, Mr. Kilgore actually said, used the term viewed entire video twice. Did you ever say or testify that the defendant had viewed the entire video twice?
No.
It's nowhere in this transcript, is it?
No.
What page you want to?
That's the entirety of the transcript. It's not in there. Now going to page 101, we're being asked questions by the defense counsel about the video. Okay? Now let's read into context everything that you testified about on the same day about this situation. Starting, Mr. Kilgore asked you, the video, you said that was from you said yes, sir, and then he said that posted up on Reddit on June 13th. He asked you that question.
Correct.
What did you say about where it was posted up or how he came to find it?
I don't know when. Well, he read it. I'm sorry. I don't know when it was posted, but he accessed it on June the 13th, 2014.
And then he asked you, and it's fair to say that you know with all certainty that's not something he Googled or searched out. It was simply a story that was a video that was posted up on that site, correct?
Correct.
And then what was your answer?
No, I can't say that.
At that point, had you determined exactly how he had gone to it and found that video and seen it and viewed it? Okay. He also asked you another question, but that's the site he saw it from, Reddit. And what was your answer?
No, I'm not sure if it was Reddit or YouTube.
Okay. And then he asked you, because the video was actually shared on YouTube and on Facebook and several other places, right?
Yes.
And what was your answer?
Yes. When I watched it on YouTube.
Okay. And then he asked you, you said that you were able to tell that he watched it twice.
Yes,
And you
sir.
said, yes, sir. And then what did you go on and how did you describe it? What was your answers?
I don't have the times. I know the date of the first one is June 13th. I don't know the date of the second one yet.
And then did he actually ask you, could it have been the same day? What did you say?
Possibly.
Okay. Did he ask you, could it have been that he got called away from his desk at work and it came back and hit resume to play the balance of it? What did you say?
I don't know.
Okay. Then he asked you, but it could be.
I would not say that.
Because at that time, did you know for sure the intricacies of where that video came from and how he viewed it?
No.
But you had no doubt that he viewed it, correct?
Correct.
Okay, and this link was he's on Reddit. He sees a link, how hot does it get in a parked car, and clicks on it. Is he taking an action to view something he sees and wants to view?
That's correct.
And from what he told you he watched on it, did he learn information about it?
That would call for speculation.
I believe that's a fair question based on what he told him and then viewing it, if he learned information from the video.
Allow.
Did he learn information from the video?
Yes.
About temperatures rising, things like that. Even if windows are cracked, you can still kill.
That's correct.
And he told you this. And in common sense, in a general sense, would you call that research?
Yes.
And who is the person that tied this video to Cooper Harris in his own words?
The defendant.
Also, when he talked about that advocate, who he said had caused the death of his child and then comes out and advocates on this whatever show that he had watched. And did you know for sure whether he watched it on the internet, TV, or which one he'd watched it on?
No.
Who did he equate that person, that advocate, to?
Himself.
And so again, from that, did he tell you that he had learned information from this show?
Correct.
We talked a little bit about child free. I'm not going to belabor this. This was, you testified on July 3rd, a couple of weeks after the death of Cooper, correct?
Correct.
Okay, as a detective who is responsible for investigating the death of a child, whether negligence, intentional, the fact that he has clicked in and typed in the website child free, are you going to address that and look into it?
I am.
And I realize this was April 28th, and a friend told him of its existence, correct?
Correct.
And he told him it was the atheism of children or something like that?
Correct.
Being told that, he still went to this page.
Correct.
Okay. And the main page, while these articles are kind of here and there, the main page, the child free, there's no doubt that that page espouses living child free, correct?
Correct.
And it's still on the same day, but even after he said grossness, did he keep on reading other articles from the same page?
He did.
And these Google chats, now these Google chats that, did those come in with emails and things like that from his main Google account?
Yes.
And were there pages and pages of records and things like that?
There were.
Were these all things that you turned over to the state and were turned over to the defense?
Correct.
All right, the parking lot video that we saw as far as the defendant at lunch. I know, just to clear up one thing, defense counsel kept talking about having to do a 180 to turn around to look at something behind you. And when he was doing that, which side was the defense turning his head?
To the left.
Is that accurate to the way he would have been turning, looking back to somebody to his right?
No.
He would have been doing this, right?
That is correct.
So the defense was turning the wrong way.
Correct.
Did you ever see any evidence the defendant would have a problem walking and texting at the same time during the videos you reviewed,
No.
out on a hot day?
No.
Okay. Did, in your testimony, you said that he immediately walked away from the car after putting light bulbs in it?
Correct.
And that's what we see on the video.
Correct.
Okay. And I hate to keep dealing with the semantics of this, but it's important to make sure we're clear. You testified, and today, or this week, and at the PC hearing, that at some point he turns his head, and it's above the frame or at the frame or something of that nature.
Correct.
Now, is that at the same point you were describing that if he'd looked or where he was, that he would have had a clear view?
No.
Is that whole process of him opening the door, coming up, going to it before he gets his head up to the frame, is that the process you're talking about?
Coach, I'm going to object to the, I mean,
This day.
Okay. What is the process you're talking about?
As he's walking up to the door.
So does he have, if he wants to look, does he have a clear, unobstructed view up until the point he gets up there to the front, the roof of the car?
Yes.
Okay. Get you to clarify one thing, just so we're sure here from this hearing, talking about inside the frame, in the car, things like that. Let me get you to read the rest of it when you were asked about this specifically by the defense counsel on July 3rd, 2014,
Well, he's gonna read something, let me know exactly what.
page 90
Page 90 of what?
of the transcript of the probable cause hearing I was just talking about. Okay, page 90.
Well, hang on. I'm gonna object. It's, if he wants to read from it, that's fine, but I think it should be in the form of probable question and answer.
Detective, can you read from this? Is it an accurate transcript? Does this put fully in context your description of how you testified the video looked back in July 3rd of 2014?
I believe so.
Could you please read the question that the defense attorney asked you, that very detailed question?
So in that video, you didn't see him get into that car. You didn't see him look around in that car. You didn't see him grab anything out of the glove box. You didn't see him pick anything up off the floor. You didn't see him look in the back seat. You didn't see him look over the back seat. You didn't see him looking around, see if anybody was watching. You didn't see any of that on video, did you? And I answered, not at the car.
So you were asked correctly back then, did he ever go in the car, any of those things, and you agree?
Correct.
Going back at lunch, he had the bag from Home Depot that he forgot to tell you about. Was there anything that you saw in that video that stopped him from opening up the back door to put him in there?
No,
Is there anything that stopped him from going to the passenger side to put the light bulbs in there
no,
and set them down? Was there anything that prohibited him from going to the back of the car where he's got that compartment to put light bulbs and store them?
no.
Heck, is there any problem, anything you know of, he would have had some problem getting dropped off at the door in the 90-degree temperatures and just walking into work with a bag?
No.
Have you seen him carry other stuff into the treehouse?
Yes.
Is he walking with a Chick-fil-A bag?
Yes.
A guitar?
Yes.
Detective, have you ever just thrown light bulbs you just bought?
No.
That's all I have.
All right, the first thing that I want to ask you about from all of that was, we'll call your attention to something specific Mr. Boring asked you about.
Yes, sir.
Messaging with Elizabeth Smith. That morning of the 18th, you testified that Ross had messaged Elizabeth Smith, "Can you come suck me today?" Right?
Yes, you can come suck me today.
Okay. And Mr. Boring asked you, well, there was no discussion about meeting up, was there?
No.
Why don't you read for the jury what her response was?
No, I'm in Hilton Head.
And what was his response?
Damn you, LOL.
So apparently she was out of town and they couldn't hook up that morning. Or that afternoon at lunch in his car, could they?
No.
I want to go back to, just real briefly, do you have a copy of the transcript with you? from
Which
July-
rule?
July
Yes,
14th?
I do. July 3rd?
That's right.
I do.
This was kind of skimmed over. Make sure we understand. Look at page 61. At line 5 and 6, and specifically, you're being asked about that public service announcement video, right? many times did he view it?
That's correct.
And your response was what?
He viewed it twice.
Okay. So your testimony under oath was that he viewed it twice.
Once again, it was cleared up. Do we know? No. But when you asked, it was accessed twice. So we don't know if he viewed it twice or not.
Yeah, but see, the thing is, you were under oath.
I understand that.
And you swore to tell the truth, the whole truth, and nothing but the truth, and you testified he viewed it twice. That's not true, is it?
I don't know,
Well, why'd you testify to it if you don't know?
because it was accessed twice.
Why did you testify that it was accessed twice?
I misspoke at the probable cause hearing. And it's possible that he viewed it twice.
Okay. So you're gonna stick with that it's possible he viewed it twice?
I'm gonna stick with that because at the time when I said that, it said 2 times. We did not know. It was accessed, viewed, looked at 2 times. It was 2 times, accessed.
But
And that's access is the word that we started using later on too. At that time, it said 2. I believed he viewed it 2 times. And then it was cleared up and we went on.
And by cleared up, you mean it was made clear that you were wrong about that testimony? He did not view it twice?
Well, it was cleared up that we're not aware, I was not aware at this time what access 2 times meant.
Okay. You are aware that there was a consultant brought in to look at this very issue, right?
Correct.
And in fact, in your notes, you discussed exactly what issues you wanted this consultant to look at, Jim Persinger.
Yes.
So this was something that was important. You wanted it looked into enough that you went to the trouble of getting an outside consultant, right?
True.
All right. But yesterday you testified that you have no idea what the results were of his evaluation.
That's also true.
Something that important, the lead detective, you weren't clued in or told or given a copy of his report or explained in any way what his results were?
No.
Do you know why it was kept from you?
Was this never brought up? I don't even know if a report's been made.
Your testimony today is that you do not know if there is a report that's been made,
I have not had a report given to me on this issue.
and you've never met with anybody to discuss it.
No.
Okay. All right, so Mr. Boring asked you about the parking lot video that we saw, so why don't we just take a look at it again? This is gonna be the video where puts the light bulb in the car and then walks away, and I want you to pay particular attention to when Ross is walking back to the treehouse, okay?
Before you go into this, how long do you anticipate this part of your recross?
I don't, Judge, I doubt I've got another 15 minutes maybe.
We'll take a morning recess. Ladies and gentlemen, we'll take a recess for the morning, close your notepads, keep an open mind, discuss the matter, enjoy each other's company. Let's be in recess.
Please watch the step going down. Go. Yes.
Y'all have a good break.
Thank you. proposed order. Obviously, we've objected to lots of things regarding the entirety of the procedure. As a form, it appears to be what we have previously discussed. I will note for the record, there are some specifics that are not in there, such as how close jurors can get to the car, if they can touch the car, how long we're gonna be out there, those sorts of things.
I believe we still need to discuss those things, but pursuant to the suggested yesterday, this order encompasses those.
Okay, well, I think we can take the touching aspect up in my charge, of which I've done one, I did two. I did one anticipating that the car, that the car would not be in evidence, but now that it's gonna be in evidence, that truncates the charge substantially. If y'all wanna come up and get a copy of what I've done. It does not have to be totally ironed out yet. Where's my bridge view that I need one. Okay. Y'all can fight over the,
Thank you.
okay, that order's been done. I have an oath for the bailiffs, and it's just pretty standard. You solemnly swear you will permit no person to speak or communicate with the jury on any subject connected with the trial, nor do so themselves except the mere showing of the items to be viewed and return them into court without unnecessary delay. Any problem with that for the state?
No.
Defense? I don't think we need to address the charge I put together. I do have the longer one, but it's just basically based on the vehicle not going into evidence, which is not the case anymore. So I edited it substantially. And we can take that up maybe after lunch. And I think then we'll have everything in place to finish up discussions about the charge, about the viewing, except meeting with the sheriff in the morning. Anybody have anything to say about what I just said?
No, Judge.
Bring the jury in.
Let's all rise for the jury.
And we still have motion 29 to deal with.
Jesse, is this yours? Thank you. I'll stick it right back there.
That's fine.
Please be seated.
Judge, I've only got a few more minutes, I think.
That's fine.
Mr. Warren asked you a little bit about my demonstration yesterday
He did.
regarding which way or how Ross would have had to have turned around behind him to see whomever was behind him.
Correct.
So, can you see the screen?
I can.
All right, so we're just gonna show and before you play it, Mr. Lumpy, what I'm gonna show you is the part where Ross is walking back from the car, and you can see this person right here on the
Yes, sir.
right-hand side of the screen.
I can.
Right, that's the person that you're talking about, correct, that was
I
walking
believe so.
past
I'd have
him?
to watch the video.
Okay, well, we're gonna watch it, we're gonna look to see if we see any of that turn into the head or shoulders or torso that we talked about yesterday. Just go ahead and play it. That's Ross there, correct?
Yes, sir.
And actually, another person walks past him.
Yes, sir.
All right, thank you very much, Mr. Lumpkin. Okay, so in the demonstration that I did yesterday, what we talked about was the fact that a man walked past him. And for Ross to see the person behind him, he had to do one of two things. He had to either turn his head 180 degrees, or he had to rotate his shoulders and torso like this to see somebody behind him. Now, the demonstration I did was to the left, but is it true that the same holds for the right? If he wants to see somebody that's behind him, he's either got to turn his head or he's got to rotate his shoulders and his torso like this to see somebody behind him.
Correct.
Okay. And you agree, we just don't see that in the video, do we?
There's no obvious.
Okay. And we talked about the fact that it appeared that he stopped twice and he was on his cell phone, correct?
He stops twice, I don't know what he's looking at.
Okay, don't know what he's looking at. I'm going to show you your report from February the 11th, 2015.
Yes, sir.
And on page 2 of the report, the highlighted area, if you could read that, please.
Then, during that time, he pulls his cell phone out and begins using the phone.
Okay. So between February 2015 and when you took the stand for me to cross-examine you yesterday, what exactly has changed that you no longer can say with any certainty that he was looking at his phone?
I don't know what he pulls out of his pocket. It could be his cell phone. I'm not sure.
Okay. Well, your report, it doesn't say, it could be his cell phone, I'm not sure. What you reported was, during that time, he pulls his cell phone out and begins using the phone.
Yes, sir.
Okay, I'm gonna ask you again. Has anything changed between the time you filed this report, February 11, 2015, and when I cross-examined you yesterday on this issue?
Sitting here looking at that video, I cannot say with 100% certainty that's what he did, was pull out a cell phone and start using it. Could it be a cell phone? Yes. It could very well be a cell phone that he's using. Want to be 100% correct though. Sitting here on the stand under oath.
Of course. You would agree that, under your theory, if he turns around and watches somebody going back to the car, that would be more consistent with your theory that maybe he knows Cooper's actually in the car?
That's true.
Okay. And if in fact what you wrote in your report in February 2015 was accurate, that he appeared to pull his phone out and use his phone, that would be inconsistent with your theory, wouldn't it?
No.
Okay. I want to ask you about a matter that Mr. Boring brought up yesterday, a few minutes ago regarding some searches that Ross did, I believe he said, for secluded islands. Do you remember that?
Yes, sir.
Remote islands?
Remote islands to move to.
Okay. And you were able to testify to that because this is something you've actually seen, correct? Okay, I mean, you've actually seen the searches?
Yep.
Okay. All right. I'm going to hand you what's been marked as Defense Exhibit 82. It's awfully tiny, Detective. Mr. Lumpkin, borrow his glasses if you need them. I want to see if you can recognize that. Is Does that appear to be the parse search for, on the Lenovo?
Yes. Yes, it does.
Okay. And that is, that's on June the 13th, 2014?
Yes, sir.
Okay. I'm gonna move defense 82.
No objection.
Admitted.
All right. And can you give me the time, the specific time, and the specific search that you were talking about?
It's 2088, remote islands to move to. The time is 6/13/2014, 03:57:46 p.m.
Can you convert that?
I'm sorry.
Is that 11:56 a.m.?
I don't know how you had it set. How did you have the UTC set?
Minus
Because it
4?
doesn't say -4, it doesn't say anything. So
All right. Give me the time that it says then.
time that it says on here is 3:57 p.m.
Okay? And what was the search for?
Remote islands to move to.
All right. What about at 3:56:43 and 3:56:48?
Solomon Islands.
2 searches for Solomon Islands?
Yes, sir.
Then immediately after that, a search for remote islands to move to?
Correct.
And what was at 11:59?
3:59 on this report says Necker Island.
Necker Island?
Necker Island.
Okay. Did you do any investigation as to any other web history around that exact same time that Ross was doing?
No, sir. Not it specifically.
You apparently thought it was important enough to make note of it and for it to be discussed in trial, right?
The prosecution did bring it up.
Okay. I'm going to hand you what's been marked as Defense Exhibit 83.
Thank
And
you.
you could look at the time and date of those searches as well.
There's no date. There's no time. Oh, there. I'm sorry. We're in the middle.
Okay, what's the date and time?
6/13/2014 at 3:56 p.m.
All right, so this is 1 minute, something that was accessed 1 minute before the search for remote islands and Solomon Islands and Necker Island?
Correct.
Okay, I'm gonna move 83.
No objection.
Admitted.
Can you tell us the name of the article that Ross accessed on Reddit exactly 1 minute before he searched for remote islands and Solomon Islands?
Looks like it's a Reddit article. Something kid who lived in the rainforest with knew.
Story or post about a kid who lived in a rainforest?
True.
That's what he looked up. That's what he was looking at, 1 minute before he started a search for Solomon Island and remote island, correct?
Yes, remote islands to move to.
Okay. I'm gonna show you what is marked as Defense Exhibit 84. I want you to look at the URL.
Okay.
I want you to compare it to the Reddit URL in the previous exhibit.
Okay.
They're the same, aren't they?
They appear to be.
Is that 84, Detective?
It is.
I'm gonna move 84.
Just a couple of questions, Judge. Is this something from the computer, or is this a printout? Is that article from the computer?
Yeah,
Or is that
it's,
something that you Googled?
It's we didn't Google anything, we just put in the same URL that's in the previous exhibit.
When'd you do that?
Want to do it today? Sure.
Okay. They objected to it yesterday, but I'm not objecting to that.
All right.
Okay. And when you go to that URL, when you go to that site, what comes up? What is in that exhibit? It's a Reddit story about what?
I am a kid who lived in the rainforest, no electricity, no running water, you name it, we didn't have it.
All right. And do you notice in that article if it mentions what island that he's on?
Solomon Island?
Solomon Island. Same as that, what Mr. Boring asked you about.
Yes, sir.
And a moment ago, I asked you about Necker Island. Do you have any idea what that is?
No, sir.
Do you know who Richard Branson is?
I do.
Okay. Do you know if that's Richard Branson's island?
I don't know him well enough, sir.
Okay, I don't know him either. All right. We talked a little bit about Leanna Harris's computer that had all her pictures of Cooper on it.
Yes, sir.
And you certainly have the capability to simply copy all of her pictures and provide her with a copy of all those pictures for the funeral, didn't you?
Objection to relevance, Judge, about providing pictures to a funeral.
He did ask about this in redirect specifically.
I sustain the objection.
You were asked in redirect something about returning the images to her attorney. Remember that?
Yes.
That was well more than a year after she had to bury her little boy, wasn't it?
I'm not sure when they were returned, but they were returned.
Just a couple. I know everybody's like, oh, Lord. When you talked about him, I think the report said a cell phone, we're saying now, it's, you want to be 100% sure what he was looking at. With that, was that something he pulled out immediately while walking past this person, or was it later?
Later.
Okay. Have you seen any enhanced photos, still shots that have been taken from these videos?
I have.
Okay. Let me just ask a couple of other questions. You were asked about Jim Persinger. Now, do you know who the direct point of contact between Mr. Persinger and, I guess, the prosecution, state police? Who would that have been? Would it have been the police department, or was he employed by the DA's office to assist?
He was employed by the DA's office.
Okay. And so his point of contact would have been us, not you.
That's correct.
Okay. You aware of any efforts of us to keep any information from you about what he told us or anything like that?
No, sir.
I know some mention was made about FBI and things like that. Did they actually do any work on the case?
Judge, I'm going to object to that. I'm going to object to that because I'm objecting to this entire line of questioning at this juncture.
Haven't-
Yes.
Can we approach?
witnesses or do any actual work on the case, or were they just, did you go to them for consultation?
They were provided copies of parts of the case file and just went for consultation.
They do any actual work on it?
Not that I know.
Same objection.
Okay, that's all I have, Judge.
Noted.
Testified yesterday that they did provide you with a binder
They did.
with some materials.
They did.
Okay, where's that binder?
It's been turned over to the DDA's
Okay,
office.
did you provide me with a copy of it?
Objection relevance.
This is all in evidence already.
I don't think that has any relevance as to whether discovery's been provided on this, and we've already ruled on whether it has to be or not.
Judge, if I may, just very briefly, Mr. Boring asked
Judge,
numerous
can we approach and
questions.
not do this in front of the jury then?
I'm just gonna sustain the objection. We
Thank
all need to move on.
Thank you, Detective.
Thank you, sir.
Nothing further, Judge.
You can stand down.
Thank you, ma'am.
Good.
Next witness.
Statement call, Detective Racy.
You solemnly swear affirm the testimony that you give to the court of jury on this matter is the truth and the whole truth and nothing but the truth. I do.
Detective, would you please introduce yourself to the ladies and gentlemen of the jury by telling them your name and spelling it so the court reporter gets it correct?
Okay, my name's David Nizam Racy. Spelling's David's common spelling, D-A-V-I-D. Middle name's Nizam, N-E-Z-A-M. Racy's R-A-I-S-S-I.
And Detective Racy, where do you work?
I work for the Cobb County Police Department.
And how long have you worked there?
It was 9 years in October.
What's your job there now?
I work in the Crimes Against Persons Unit, which we investigate adult persons crimes, rapes, robberies, homicides.
Okay, and previous to that, what division or unit did you work with Cobb County PD?
Prior to going to the Crimes Against Persons Unit, I worked in the Narcotics Unit. It's called MCS Narcotics. It's a multi-jurisdictional task force, and I worked on the undercover side.
Are you also involved with the military?
I am.
Have you just recently been spending a lot of time down here?
I have. So besides my law enforcement career, I've also had a military career. Prior to joining the Cobb County Police Department, I was in the United States Marine Corps, where I served in the Presidential Support Program, basically up at Camp David, the Presidential Retreat. I did that for 4 years active duty. And when I got out, I stayed in the Marine Corps Reserve, and then I switched in 2010 to the Air Force, doing security forces, which is their version of military police. And recently I switched over to the Office of Special Investigation, which is the Air Force's felony level investigative unit. And I came down to FLETC down here in Glenn County and attended the CITP training, which is the Criminal Investigator Training Program. It's the basic federal law enforcement program, the same one that ATF, Secret Service, U.S. Marshals go through. And then after that, there was an add-on course for the Air Force that's called the Basic Specialized Investigator course. So total, it was just shy of 6 months that I spent down here in Glenn County, and I graduated about a month ago from those courses. So I have my military law enforcement, and I have my civilian law enforcement as well.
So you went back to Cobb in September then?
I did.
So we were kind of ships passing in the night, I guess.
Yes, sir.
Okay. Tell the ladies and gentlemen of the jury what your job was with Cobb County Police back on June 18, 2014.
I was assigned to the Crimes Against Persons unit, and I was working the evening shift. Then we were broken up in that unit. There was a robbery side and a homicide side, and I was assigned to the homicide side. We've since then combined, so everyone kind of works together, but at that point in time, I was specifically assigned to the homicide unit.
And as a part of that afternoon, did you respond, or were you asked to respond to a crime scene over at Acres Mill in Cobb County.
I was.
Okay, who'd you go with?
I went with Detective Stockinger. He's also in the Crimes Against Persons unit.
And just kind of to get through it, when you got to the scene, about how long were you out there?
I'd say about 15 minutes around, give or take.
Okay, and after you got there, did you and Detective Stockinger go anywhere else to basically, did y'all go to deal with other parts of the investigation, not at the scene?
We did.
Okay, and what's the first place that you went after you left the scene?
We went to the Home Depot, one of their parts of the facilities, not the actual corporate headquarters, but what they call the tree house. It's the separate detached portion of Home Depot, but we went to there. It's
Okay.
where the defendant worked.
And who did you go there and did you speak with anyone?
We spoke with the defendant's wife, Leanna.
And with that, did you audio record, video record, or how did you record it?
It was audio recorded on my department issued just audio recorder.
Now, after you spoke with her, did you go to, well, first of all, did you help move her car, move it somewhere?
I did.
Okay, what did you move it into?
Okay, so her vehicle was actually parked on the curb, and so in order to basically have it not in the way, since it was parked on the curb, I actually offered, I think she might have even asked, but I got into the vehicle with her consent, and I parked her vehicle in the the visitors' parking spots that were there in front of the business there. And then she also asked for her purse, which was inside the vehicle, so I grabbed her purse and brought it to her.
Now, after that, where did you go? After the tree house?
Okay, after the treehouse, we actually gave Leanna a ride. Ultimately, she went back to Cobb County Police Headquarters. I was dropped off at the defendant's apartment. So first we went to the defendant's apartment. I got out, met with Uniform Patrol that was there. Detective Stockinger continued with Leanna to headquarters.
And once you dropped off, where did you go?
I stayed at the apartment there, and basically a search warrant was executed at the
It
apartment.
was going to be my follow-up. What were you waiting on?
We were waiting on the issuance of a search warrant.
Okay. And while were you there, was a search warrant issued, and did you go in with crime scene technician Shumpert?
I did.
Okay. And who was there assisting you, if you remember?
Detective Adam Check, another detective in the Crimes Against Persons unit, he actually was on the robbery side of the house at the time, and he actually showed up to assist in executing the search warrant. The crime scene tech, and I believe some of the Uniform Patrol remained there just as uniform presence there on the scene.
Were items pursuant to the search warrant collected at that scene?
Yes,
And at some point, did you return to Cobb County headquarters and assist Detective Stoddard with any other duties there at headquarters involving the defendant, Justin Ross Harris?
I did.
Okay. Do you see Justin Ross Harris in the courtroom?
I did.
Could you identify him by where he's sitting and what he's wearing?
Yes, he's the third one over. It looks like he's wearing a blue tie, white shirt.
Your Honor, I ask the record reflect the detective has identified Mr. Harris,
It
the
may.
defendant. Detective Racy, what was the duty you were going to help that evening with Detective Stoddard doing?
Okay, so when I arrived back at headquarters, interviews had already been conducted, and I was sitting at my desk. Detective Stoddard asked if anyone could take photographs of the defendant. What we do is it's standard practice and procedures. Once we've had someone arrested, while they're still at headquarters, basically search incident to arrest is what we call it. We photograph them as they were after the interview. There's a couple reasons why we do that. We also did that in the narcotics unit. It's just to document what the clothing they were wearing, how they looked, if they had injuries pursuant to, for example, obviously it didn't happen in this situation, but a foot chase or something like that, documenting any injuries they have. Sometimes tattoos, if they have gang-related tattoos, it's a good way to document what's going on. In this case, it was just taking photographs of him and the clothing that he was wearing because that could be evidentiary in the case. So I used my department-issued digital camera to take those photographs.
Now, while you're doing this, was there any interview or anything ongoing in that room that would necessitate recording the interview room?
No. At that point in time, Detective Stoddard asked me to do that. I grabbed my camera. I went in there, and at that point in time, there was no interviews. I wasn't there. My purpose, my mission was not to interview him, so I just had him stand up, took his photographs against the wall, and I opened the door, and Detective Stoddard was actually walking by, and I believe he stopped to speak to some supervisors, and I asked him if he had anything else that he wanted to do with him before I left the room or before we took him back to the holding cell that we have there in the office.
And did the Detective Stoddard walk in and actually tell him what his charges were gonna be?
Yes. At that point in time, Detective Stoddard said yes. And when I asked him if he had anything else, he said he was just going to tell him the charges. I stood by in the room with him just as a second person. Obviously, you're telling someone that they're being charged with a very serious crime. I would hate for Detective Stoddard to get in some sort of physical altercation by himself. So I just stood by in the room. I didn't speak. I just stood by as pretty much just a witness and there for Stoddard.
Okay. Now, once Detective Stoddard came in and informed him what the charge was going to be, he's going to be charged with felony murder based on cruelty. Was there anything that caused you to decide to turn on your camera?
Yes.
Okay, and tell the jury what that was. What did the defendant say, if anything, that struck you and caused you to then turn on your camera to record the conversation?
Okay, so Detective Stoddard did tell him he was going to be charged with cruelty to a child and also murder. At that point in time, the defendant began questioning why he was being charged with it and basically saying he didn't understand, that he hadn't told us anything other than it was an accident, and he didn't understand why we were going to be charging with that. At that point in time, he actually said the words malicious intent. That kind of triggered in my mind. I was kind of confused of how he knew that language and how someone would know that, and it kind of struck me as being off. So at that point in time, I realized when I walked into the room, I hadn't seen the red light. When the recording is gone, there's a red light when you're walking into the room. I realized that red light wasn't on, and I realized I wanted this conversation to be recorded. I felt like it needed to be documented.
So so I was going to ask, what did you do in order to try to memorialize after that moment where he brought up malicious intent? Did you try to document?
Yes. So I had my department-issued camera, and I tried to be as quiet as possible, looked down, tried to turn it from just basically snapshot mode to the actual recording mode to record a film or video, and I actually turned it on there. I actually made a mistake and took a photograph of my foot in the process of trying to get it on quickly, but I was able to turn on the video mode and start recording. And I didn't want to immediately snap it up and make it obvious that I was recording. I was trying to be somewhat not so obvious about it to interrupt basically what the conversation was going on at that point in time. So I just slowly just tilted it up, doing my best to basically record what was going on at that point in time.
And the jury's already seen this video. This wasn't any Steven Spielberg type recording, I assume.
No,
Okay.
it wasn't.
Okay, and that video that have you reviewed that video, and is that a fair and accurate recording of the conversation that the defendant had talking about the charges and things like that with Detective Stoddard up until the time it ceased?
Yes.
Okay. Now, throughout the investigation, did you also go on and interview several girls that the defendant had contact with and things like that?
Yes, I did interviews based on Detective Stoddard's request to do more of the, I guess, peripheral interviews. He was focusing mainly on the main meat of the investigation, and some of us were assigned roles to investigate some of the outside stuff. So I did interview a lot of the females and a gentleman during this investigation.
And we discussed roles and things like that. So basically, was that just the rest of your role was following up on other interviews? Did you have any other main role in this case, or was that it?
No, that's pretty much it at that point in time.
I think that's all I have, Judge.
Cross-examine.
Hey, Detective, you doing okay?
Yes, sir.
Just a few things and follow up. Elizabeth Smith was one of the people that you interviewed.
I'd have to look, sir. I interviewed a few females.
Okay. Do you need a copy of your reports or anything?
I can look in unless you have a copy available.
Yeah, I got a copy available.
Okay.
You wrote a number of reports, right?
Yes, sir.
Does that look like your report on the interview of Elizabeth Smith?
Yes, sir.
You see what I got highlighted there?
Yes, sir.
What did Elizabeth Smith tell you?
She stated she wanted to come to Marietta to meet with him. Elizabeth stated she could not because she was in Hilton Head, South Carolina.
Elizabeth Smith told you that he, being Ross Harris, wanted her to come to Marietta to meet up with him, but Elizabeth stated she could not because she was in Hilton Head, South Carolina.
Yes, sir.
And she was talking about that very day, the 18th.
I'm not sure. I'd have to either listen to the audio or get
All right.
refamiliarized with it.
Read the first sentence of the paragraph. Day of the incident would be the 18th, right?
Yes, sir. It does look like it was, they were speaking about that day. Correct.
She told you Ross was wanting her to hook up on that day, and she conveyed she couldn't do it because she was in Hilton Head.
Yes, that's correct.
Okay. When I asked you a little bit about this exchange that you have testified to regarding Detective Stoddard telling Ross about his charges, and I believe the words you used were, I didn't write it down, but he disagreed. He disagreed that he was being charged.
Correct.
Is that fair to say?
He began debating
Yeah.
why he was getting charged with a crime.
And you don't disagree that that is extraordinarily common, that people say, listen, I'm not guilty of this. I didn't do this. I didn't mean to do this. I didn't intend to do this. There's nothing unusual about that at all, is there?
Well, I believe the way in which he was doing that was what was not normal.
The way.
Correct.
You didn't think he was behaving or acting or talking in the way that you thought that he should?
Well, specifically the wording in which he was using was vernacular, was language which was not of a layperson. Certainly, as a police officer or a lawyer, you understand what malicious intent or malice is. That's pretty specific to certain statutes. So the words that he was using, I would say, more caught my attention than just him simply saying that he didn't want to be charged with a crime.
Okay. You agree that you're aware that throughout the entirety of the interview, Ross had told Detective Stoddard numerous times this was not intentional, this was an accident.
I had no idea what was going on prior to. I was not present in the office when the interviews were taking place. I was not watching the interviews. I was at his residence during the search warrants.
Okay.
So I didn't know what was normal, what was going back and forth at that time.
Well, the jury has seen that, so whatever he said, apparently it didn't work because Ross got arrested and Detective Stoddard charged him, correct?
Ultimately, he was charged with the crime, yes.
And so Ross changed his lingo or language and said there wasn't any malicious intent, right?
Correct, he did say that.
Okay. And that's certainly absolutely consistent if he were to have previously said, I didn't mean to do this. This was an accident. I didn't do this on purpose.
Again, I believe what I took issue with, or not necessarily issue, but what I recognized was malicious intent. I know I learned malice in Georgia Code when I went to the police academy. I had not even thought of that until I got back into the homicide unit just a couple months prior. So for someone who knows what malice is, I took that as very strange. And so that's what triggered me saying, what's going on here? And so that's why I clicked on the video.
All right. At the time that you heard that, did you know that Ross's brother is not only a police officer, but the head of the police academy in Tuscaloosa?
No, at that point in time, I had no knowledge of anything like that.
All right. At the time you heard that, did you know that Ross had worked as a police dispatcher for more than 3 years and actually knows 10 codes?
At that point in time, I had no knowledge of any of that.
What are 10 codes?
Well, 10 codes are part of the codes and signals that police departments use.
Okay. Were you aware that Ross was college educated?
At that point in time, I didn't know much. I do know that The license plate on the vehicle, when I saw it at the scene, had a Alabama tag on it. That would have been an assumption to say that he was college educated. I did not know anything about his background.
Brian, were you aware that he had a professional job as a web developer?
Again, I did not have any knowledge of any sort. I knew he worked at Home Depot. I did not know the type of job that he did at that point in time.
Okay, okay. But you had been at his house,
Correct.
all right, and so you had seen that in his house, he had a television
There was a television.
where he could get shows like CSI, Criminal Intent, things like that?
I don't know if he has cable. I don't know what he watches, but there was a television.
Okay. But you knew that he was being charged with a serious crime,
Correct.
and you heard the 2 words that he said, malicious intent, and you believed that there was something nefarious or suspicious about that.
I thought it was strange that he was using that terminology, which, quite honestly, I had not even used that terminology myself in being a homicide detective. Most of the time, when we even investigate homicides, murders, and we charge someone, we charge them with the felony murder.
That's not responsive to what I asked, Judge.
Ask a question.
Are you familiar with with what confirmation bias is?
That was the question.
I've moved on, Judge. He didn't, he was non-responsive to what I had asked.
You can finish answering.
If you could restate that question again, just so I'm clear on it. I'd
Well,
appreciate
I'll be
it.
honest with you, your answer was so long, I forgot what the question was.
Well, that's not appropriate. You're going to ask your next question.
Okay. Are you familiar with what confirmation bias is?
No, sir, if you would explain it.
Are you familiar with the principle that we see what we want to see? We hear what we want to hear. You familiar with that principle in investigating and interviewing witnesses?
I could say I'm familiar with it.
Okay. People believe what they want to believe. Isn't that true?
I believe they can. I don't believe that all people do, but I believe people can possibly, if you can believe certain things.
We see what we're looking for often, don't we? And so if we're looking for something suspicious, or we're looking for something nefarious, and we believe that somebody's up to something, then that's how we're going to see and hear and perceive anything they do or anything they say. Isn't that true?
Well, that might be true for some people, but in this case, I don't believe that that's what was going on. I believe that as an outside person just coming into this, it did look strange to me. I recorded it. I'm just trying to document facts. That's all we are doing at that point in time is fact finders. I'm trying to just document what was going on. It's someone else's decision if it is suspicious or not, but he did use those words. I did recognize that he used those words, and I wanted to begin documenting what else was going on in that interview. It's not my place. I did not know the context of what was going on beforehand. I just found that odd that he said that.
Okay. And you've testified a little bit about your experience, and you've been to homicide school.
I've been to homicide investigation courses,
Okay.
but
And
there's
did
no
that-
homicide school per se.
All right. You have to take continuing education classes every year, a certain number of hours at least, right?
Yes, the state of Georgia does require a minimum number of hours to stay post-certified.
Okay. And in any of your training that you've received so far, have you received training on how to testify?
Of course.
Thank you.
One question, are you familiar with any, and they asked if he was a dispatcher in Alabama, are you familiar if any of the homicide statutes in Alabama have the term malicious intent?
They do not. The state of Alabama does not have malice or malicious intent in those code sections. That's something specific to Georgia law.
When did you look that up?
Actually, today I looked it up.
Who told you to look it up?
Well, I looked it up on paperwork that was provided by the district attorney's office.
All right, well, did you look up the fact in all of this entire file, you're aware that Ross never Googled or researched the words malicious intent?
Objection, relevance, and foundation. He's not the lead detective, he'd have no way of knowing that.
Well, as to relevance, I overrule the objection. As to foundation, there is none.
Have you been privy to any other part of this interview, this investigation at all?
I've been around in the office when the investigation was being conducted and when certain discussions were had. I've been in the office, correct?
And that includes being around the lead detective, Detective Stoddard?
Correct. I do work in the same office he does.
And the secondary detective who was Sean Murphy?
Yes, he
Is that
works in the
true?
same office.
And you were involved in the, a couple of search warrants in the case, executing some search warrants?
Execution of search warrants, correct.
Right. You interviewed a number of witnesses, Caitlin Hickey, Jacqueline Robledo, Molly Sims. Is that true?
That's correct.
You met with Leanna Harris at the Home Depot
That's correct.
and interviewed her.
I was present. I was not the lead interviewer. Detective Stockinger was, but I was present.
Okay. You interviewed Elizabeth Smith.
Correct.
You interviewed two firefighters at the scene, Alvin Ashurst and Michael Beckman,
Correct.
or Beekman, right?
Correct.
You photographed and recorded Ross at the lockup.
At Cal Police Headquarters, not
Headquarters.
lockup.
Okay. All right. So it's fair to say you know a lot about this case, don't you?
I know my portions of it, and I've overheard discussions about it.
Okay. Well, in anything that you've overheard, you're not aware that there was ever a search for malicious intent, are you?
I'm not aware. I don't know. I didn't do any of the computer analysis.
Okay. Thank you.
Nothing further, Judge.
You can step down.
Thank you, Your Honor.
Yes, sir. Next witness.
May we approach this briefly on schedule?
Yes. There's some work that I need to do with council, getting ready for the next step of the trial. So I'm going to excuse you. Y'all can have a bit of a break, and then your lunch will be here noonish. You know, Ms. Risa does a real good job of taking good care of us, and she will continue to do so around noonish. So you'll have a little bit of a break this morning. Just kind of relax, enjoy each other's company in your jury room, then have your lunch, and we'll resume. We'll pick up the trial later this afternoon. So close your notepads, open mind, close mouth, have a good break, then have a good lunch.
Let's all rise for the jury, please. Please watch your step going down.
up motion 29 and let's see if we can take a chance to talk about the proposed charge. The oath is good for the jury on the view. Get all that done. Then regarding the view, all that will be left is for the defense to go out and observe what's been done with the car seat in the defendant's vehicle and report back on any problems with that. And then in the morning for us to meet at 8 to observe the placement of the vehicle before the jury's view. So those are the two things I'd like to do. All right, defendant's motion 29, I'm ready to proceed.
Mr. Rodriguez can handle that for us.
Very good. And when you're ready, Mr. Rodriguez, I know you're setting up.
It's not necessary.
Is he here?
Who was?
He's here. Okay. Well, Judge, I don't need to make any sort of opening argument. We can go right into evidence. If Mr. Dustin is here, we'd like to call him to the stand, please.
Judge, I'll object to that, and if I can state my rationale, I think we can really speed things along regarding this motion. The defendant has filed a motion number 29, which has already been ruled on by the court in an order that you signed addressing motion number 21, which is the admissibility of certain 3D scans that the state prepared. And you remember we had a lengthy hearing at which time Detective Stoddard and David Dustin testified and gave you testimony about the validity of the software. Motion 29 seeks to rehash that, and the only thing that it adds to it is a discovery component, which can be handled just by making argument only. So the state is of the opinion that there's no need for this court to take any additional evidence. You've already ruled on evidence regarding the 3D scans, and that testimony suffices to establish the validity of the scanning equipment and the demonstrative aids that we hope to present before the jury. The only added thing that they've added in motion 29 is a complaint about discovery, about some newly created scans, which I can give some information about, but that's not going to require any additional testimony. So I'd ask that you just follow your ruling statement in motion number 21 in your order to that effect, and let's just address the part that hasn't been addressed yet, which is complaints about discovery.
Yes, sir.
Well, Your Honor, I would disagree regarding the difference between defendant's motion number 29 and 21. The difference is not simply that we have been provided over 30 days since starting to pick a jury a new scan and new evidence and a new report from an expert. It's that there is a new report because a new scan was done, which is materially different from the first scan that was conducted in the spring of this year. I'd like to present evidence on the differences between those two scans, why those differences, why the new scan needed to be conducted, explore exactly what those differences are and what sources of information were provided, because if you remember, the court's order was that this was an animation, and that an animation is a demonstrative aid. Well, a demonstrative aid can only be used to illustrate testimony and not draw conclusions. And I'm quoting Your Honor's order. If that's the case, then we need the court ought to know, before admitting this new piece of evidence, what testimony this new scan is going to illustrate. A demonstrative piece of evidence is not probative of anything in and of itself. It doesn't go back with the data. It's of no value at all unless it illustrates the testimony from the witness stand. So I would disagree. There's more than just the added component that this piece of evidence was produced to the defense well after the start of trial. It's more than that. This is a new piece of evidence that was created during the trial. We haven't had a hearing on this piece of evidence. Motion 21 was about the other piece of evidence that was created by the same expert. It's not the same thing. If it were, why do we have it?
What do you say?
explain how we even got to this position. This is based on some questioning that was posed to the investigator Grimstead during his initial testimony. And you may,
This ought to be coming from the witness. He's explaining why this was done.
Excuse me, this is basically in the nature of opening statements.
there was some questioning posed on cross-examination by Mr. Lumpkin, wherein a topic was raised with the investigator involving some doll that the state had not even attempted to use in our direct examination of Investigator Grimstead. And during the course of that, it was pointed out that a car seat was adjustable and that it could be raised or it could be lowered. Based on that, the state, out of an abundance of caution, asked Investigator Grimstead, you'll remember we had a discussion about looking at the evidence during breaks, asked Investigator Grimstead and David Dustin to come back down to Glenn County where the vehicle was so we could place that child's car seat in the precise location, confirming that the adjustment was not off, so that the interior of the vehicle could be scanned and we could confirm the accuracy of the scans of the interior of the vehicle. That was accomplished on October 15th and 16th during the middle of this trial. We didn't have that prior to then because the scanning process took place over those 2 days. Now, I want to point something out here, Judge. The initial scan of the Chick-fil-A restaurant, you've already ruled on that. We have not rescanned the Chick-fil-A restaurant parking lot. The initial scan of the Acres Mill area where the defendant parked his vehicle, we have not rescanned that area, and you've already ruled on it. You've heard testimony about that. All of the scans that have been done in this case, you've already ruled on, with the exception of the rescan of the interior of the vehicle, which has a negligible change, I think you'll see. So the issue here is really a discovery issue. It's not the validity of the scans or the prejudicial impact. Those issues have already been resolved with your prior order. We just have an additional scan here based on something that was brought up on cross-examination of a particular witness, that being Detective Grimstead. So I'm of the opinion that you don't need to hear further testimony on that. We've litigated the accuracy of the equipment. We've litigated the credentials of David Dustin. We've talked about the validity of the scanning equipment and how we intend to use the demonstrative aids. Those are all questions of law, and those questions of fact have since been resolved. The only thing that remains then is, okay, well, has there been some sort of discovery of violation as is alleged in their new motion?
All right, well, there needs to be a discussion about the alleged discovery violation. I agree with largely what you said, Mr. Evans, except for one piece. There was some reason for doing a new scan. I see the validity of taking testimony on that limited issue only. Apparently the witness is not here, but he's going to be called before he gives his testimony. We can explore that only limited to this additional scan, and whatever questions the defense wants to ask about that before the jury comes in, as long as it's very limited, I'm going to allow. And we can take that up regarding defendant's motion 29. So let's focus on the discovery allegation. I only need argument on that. What says the defense?
Your Honor, based on Mr. Evans' own admission, this was based on how the trial was going. It was apparently brought to the attention of the state through cross-examination of the state's witness that they had not accurately measured the car seat and its position within the vehicle. They should be stuck with that, because in preparation for trial, our strategy and how we cross-examined witnesses was based on the state of the evidence when we announced ready for trial. To now allow them to create a new piece of evidence in an effort to save what has been brought and exposed before the jury allows them to circumvent the very, very clear statutory rules that we have. 10 days before trial, unless extended by the court. 10 days before trial, this was not done. This was done October 15th and 16th. I mean, I just think it's crystal clear.
I have actually some authority for the court that might be actually OCGA 1716-4, and I intentionally included all of the annotations as well because I'm going to cite to some specific case law that's directly on point. I first want to point out, Judge, that while there are requirements for the discovery of certain scientific information, we can only give discovery that we have, and if we don't have it, we're not capable of giving it. We gave the defense this new scan as soon as we had it. So they are no worse off than the state is in terms of their review of the evidence. And I'm not conceding that there was a full problem with the first initial scan. We just want to make sure that we got it right based on some questions that were raised by the defense. So I take issue with that point. I would say that this is probably a more accurate scan based on all the information we have available to us now. Looking at the statute and what's required, there are some specific cases that are cited there, and I want to point out some of them. One that appears to be closest to being on point is Billings versus the state, and it's in the annotations. You can find Billings. A lot of these cases, by the way, Judge, cite to the predecessor of this discovery statute, so they cite to the old law, even though it's still good law in terms of what's required. But if you look at Billings, it's in the annotations. I'll just give you the site. It's 161 Georgia Appeals 500. This is a situation where the state actually conducted some testing after the commencement of trial. And they did that because it was about an issue that was raised by the defendant during the course of the trial. So what happened is the state said, all right, well, let's go back and look at this issue and make sure we got it right. On page 2 of the Billings decision, which is decided in 1982, I'll read the quotes. The unrebutted testimony of the forensic scientist was that he was called on the morning of the same day on which he testified and was asked to perform certain tests on the clothing of the deceased. The prosecuting attorney stated in his place that the state had not foreseen any need for such testing until confronted by the appellate's evidence that a fatal shot was fired while the pistol was touching the body of the victim. It appears without contradiction that the evidence here involved was not in the possession or available to the district attorney when appellant's motion for discovery was filed or when the trial began. They went on in Billings to affirm the conviction. I will point out, and I'll candor to the court, that it comes up as a red flag. It was reversed on other grounds. Another legal point later had nothing to do with that discovery issue. In similar vein, you'll also see in the annotations, Law versus the State, 251 Georgia 525. That's a 1983 case, pointing out that our Supreme Court has said, well, if you have no scientific writing available to you, there's nothing that can be provided to the defense. Up until the point where we asked that the rescans occur, we had nothing that could be provided to the defense. Now that we have those, obviously we've fulfilled our obligation by providing it to them. Daniel versus the state, this is 180 Georgia Appeals 179. That's a 1986 decision. They affirmed in that case where the report was given the day of the testimony of the witnesses. We actually gave this to them with enough time that they could do some research on the issue, review the scans. They've now had them probably for over a week. The only additional thing that we gave them is a scan of this courtroom, just so we can help to, as a foundational matter, establish the validity of the software. I think you saw that we did that in the prior hearing that was conducted up in Cobb County as well. And the last case I'll cite is Henson versus the state. This is 168 Georgia Appeals 210, 1983 case. This is a situation where appellant complained that the state never provided anything at all. And the court went on to hold, well, if the defense is already aware of this, if they already have knowledge of it, if there's already some base for them to already know about it, it's really not newly discovered scientific evidence that's subject to the statute anyway. And they went on to affirm there. This is important because they've got the crime scene picture, they've got the video, they've got the scans, they've got the rescans, and it's all really cumulative of all of the same things. All that we have here is an attempt to make sure that we've got it 100% accurate in terms of the scans of the interior of the vehicle. And they're, again, no worse off than us because we didn't have that available to us until we had made affirmative efforts to get those rescans done. So for those reasons, we ask that you find that there's no discovery violation.
Your Honor, the first time that we had this motion, it was put before the court that this animation was 100% accurate. and now it must be more than 100% accurate that we've been confronted with a new scan. This information that supports the creation of this animation has not been made available to us before trial. Why? Because new measurements were done during trial on October the 15th and 16th to create the animation. Those new measurements to make this new scan were not done. That came from the witness stand when Detective Kerry Grinstead testified. I did not do that measurement. So the state asked him to do that measurement. We don't know what it is. We have yet to receive that piece of evidence, that piece of discovery. We have not received. But with that information, they created a new piece of evidence, this second scan. And why it is important, and I believe Your Honor will see why it's important to take evidence here, is because the first scan, if you can remember, the first video, showed a caricature of Ross Harris with two arms inside the vehicle. Okay? Now that we have had testimony from Home Depot security personnel that reviewed the surveillance video and testified before the jury, that it appears that he has one arm inside the vehicle and he's kind of turned and his head is tilted. Since then, and since Detective Grinstead reinstalled the car seat with a new measurement that we're not aware of, they have now done this new video animation that doesn't have the caricature of Ross Harris at all with arms inside the vehicle. So Your Honor will see that this animation not only does not represent the discovery and the information that we were provided before trial, but it now represents testimony that was absolutely not elicited in front of the jury. It's inconsistent with the testimony. I submit, when you see this piece of evidence, having listened to the testimony, there hasn't been a single witness to testify to the recreation that you're going to see. Not a single witness has said, Mr. Harris just stared at the vehicle with his arms by his side with the door open. No witness has said that, and no witness will say that.
Well, first of all, trials are not static in nature. They're dynamic in nature. And things change in trials. We all know the situation of a witness who's been interviewed and interviewed and interviewed, and then they take the witness stand and something new develops, something changes. And each of you has a right, if that occurs, to go and develop your case around that in a manner consistent with your respective positions of prosecution or defense. If the defendant were in a position that something changed and they wanted to develop it, they're entitled to do so. The state has the same opportunity. In terms of discovery violations, I don't find that to be the case. Notice has been given as soon as it was available. There's been adequate time. And in fact, the way you've developed and articulated the motion and your argument is indicative to me that there's been adequate time for preparation. So as to that aspect of defendant's motion 29, that there are discovery abuses, I do not find that to be the case. So that first step is taken, and defendant's motion 29 is denied in that regard. I do not intend to take an hour of time with the witness about this new scan. I mean, the basis have already been done. I've had the testimony on it. It's going to have to be very sparsely done. It's going to have to be well developed and very targeted and very surgical as to what we're going to do. I'm going to get very limited testimony. I'm just wanting to be very clear with you all. But I will give you an opportunity to develop the reasoning behind a new scan and what the new scan shows, whatever it might show. All right, I will do that. All right, have y'all had a chance to look at my proposed charge?
The state has, and we're satisfied with that, Judge.
And the defendant?
Admittedly, Judge.
Take a minute. Which I may have given away my only copy. No, I've got it.
Jason, is this our copy? We got to keep this copy? As to, as to
Content.
the form of it, I mean, obviously, we're not waiving any objection to the entirety of the procedure.
No, I don't anticipate that.
And I know the court's answer is going to be this is something we're going to take up, but the charge itself does not discuss distance.
Mhm.
And I think that's probably something that we want incorporated.
I don't have a problem with that. Have y'all talked about this?
No, ma'am.
Well, I think it would be prudent. Many hands make light work. Y'all may agree.
Okay.
And I just think that as a matter of professionalism and as a matter of the excellent work all of y'all have done, coordinating with one another, speaking with one another, it's not time to quit doing that. So, talk. I'll sit right here. Because the issue is that they can walk around, they can't touch, they can't sit. So in terms of distance, I mean, I don't expect to give them rulers.
Okay, I would just ask for an opportunity then for us to talk about it over the break. If we come to some agreement, fine. If not, then
Maybe y'all can talk right now.
length of time viewing is something that we may also want to incorporate.
I agree, talk.
And they probably need to know, hey, we're only gonna be out here for X number of minutes or whatever.
If y'all will talk first, talking to me is not nearly as valuable as talking to each other. At least not to me.
They don't.